All right. Welcome to Catalyze Your Creativity. This talk is primarily intended for a designer audience, but it really applies to anyone in the creative industry who produces some form of intellectual property, whether that be code or video, imagery. Any of us can use open content licensing to help speed up our workflow and save time, but without having to compromise the integrity of your project or the quality of your work. Also help you save money too. My name is Darius Garza, and I'm a web designer first and foremost. I still do a lot of print stuff, do a lot of work in identity and branding. Um, People say I make a lot of pretty pictures, but there's a lot of strategy that also goes into that too. I end up doing some UX stuff, wireframing, content strategy, client intake, that sort of thing. But I'm most comfortable with the execution of the web design after all that stuff's been sorted out. I've been working on the web for around 5 years. I've been mostly doing work with Drupal and content management, dynamic systems kind of stuff. Still work a lot with Drupal, a little bit of WordPress stuff. I've worked a lot of the time as an independent contractor. Recently was at Chapter 3 in San Francisco for a couple of years, but then I just transitioned back into working independently. I spent a lot of time working with a consultant called Canopy Studios, which is sort of like a decentralized network of freelancers. And we have an amazing sales team who helps us find gigs and does all that yucky numbers stuff. And they take a cut of that and they help us find work. So, it's independent, you still feel like you have a network and a team to reach out to if necessary. This is my Twitter handle, Darius_Garza, and you can also email me, Darius@clickburn.com. So let's get started. This is what I like to call the designer's dilemma. Typically, when you're working on a project, you end up in a scenario where a client has to pick from two of these elements. Work your project done quickly. Do you want it to be really good quality? Or are you on a budget and you just need to produce something that works? So usually you can't have all three of these elements aligning with each other, right? But if you pick two of them, cheap and good, the work is typically going to be slow, right? They're not spending a lot of money on it, but you want to do the best work that you can. Maybe this is a side project or something for a nonprofit that you care a lot about that you're doing. That's not your day job, but you still want this to be a good portfolio piece or something really good for this agency that you're doing. Since they don't have all the time and the money, it's not going to be your first priority. But eventually, it'll get to where it needs to be and become something that you're really proud of. But it's not going to happen overnight. More high-end clients, normally you hear from them that they want it done like yesterday and it better be amazing. Well, then they're going to have to pay for that. You're going to probably put all of your best people on it, work late nights, work in hectic, stressful situations. That's going to be your number one priority. They're going to find some way to pull off a miracle and make things look really awesome, but you're going to make them pay for it. And the third scenario is that when a client wants something really fast, but they say that they don't have any money. So you're not going to be able to put as many resources on that and spend as much time as you would want to. So the end product of that is going to be a little bit mediocre, but at least functional. And now all of these three case scenarios can work depending on the type of work that you're doing and what your expectations and goals are. But what if it was possible to actually transcend this dilemma and produce work very quickly with a lot of integrity, but yet still not having to spend a lot of money? Well, I say that through leveraging open copyright licensing tools, that you can help perform such miracles by speeding up your workflow, lessening the amount of money that you're spending on these tools, but still being able to produce things that are of high caliber that you can be proud of. So this is a short overview of what we're talking about. I'm going to tell you why I care, a little bit where I come from, how I got involved with the open world. Then I'm going to walk you through a little bit of the basics of copyright, because it's really difficult to understand open licensing without a basic understanding of how copyright works. It's kind of complicated. So I'm going to walk you pretty quickly. It'll be a crash course through some of the fundamentals just to give you a more fundamental understanding of how to leverage these things for yourself. And then at the end, I'm going to walk you through some really cool tools and resources that use open licensing that you can use in your work and used to help you produce better work. So Drupal was my first introduction to the world of open source. I really didn't know much before it. I was in college. I was taking an undergrad web design class. Before that, I was writing all my own HTML, and it was a nightmare. And I'd never really known about content management or PHP or dynamic anything. So Drupal was a total game changer, and it was the first time that I didn't have to steal a piece of software. As a student, you don't really have the luxury of buying this expensive Adobe stuff. So, I thought at one point that shareware or open source was just shareware, or another word for something that you really don't want to work with. But I learned that its true power was kind of amazing, and I'm like, wow, how far does this rabbit hole go? Like, how in the world is this free? I wanted to learn more. I thought it was really cool that people would contribute time out of their own world and give back and create something that was sort of bigger than themselves. So, a lot of people say that the moment when you discover open source is kind of like drinking the Kool-Aid, right? It sort of has this cult-like mentality. And I'd have to say that for the most part is true. I've been working with Drupal ever since I was introduced to the platform. It has its advantages and disadvantages, but it's you come for the software and you stay for the community. I think that's absolutely true. So after discovering this whole open source thing, I was still in grad school doing some research, and I wanted to learn more about the different types of content licensing and the different ways to apply this. So I discovered this book, Free Culture, by Lawrence Lessig. He is a lawyer who used to work at Stanford. Now he's at Harvard. His work originally started off with digital human rights and internet activism. He doesn't do that as much anymore. He's sort of changed his focus over to our democracy and our government and working on congressional reform. But he's still a big inspiration for me and one of my favorite overachievers. And he's laid the groundwork for a lot of the open copyright licensing tools that we'll be talking about later. He's one of the premier founders of the Creative Commons license system. So he still has that in his legacy. And the third reason why I'm so into this open licensing thing is because I'm a serial volunteer, and I do a lot of work for free. And I think that, as a designer, it's kind of hard to give back in the open source world. It's pretty code heavy. It's kind of complicated, and there aren't easily many opportunities which are so clearly visual. So I got involved with camps and cons, and whatever I could to use my design as a way to help them and grow the community. So in these scenarios, you have low budgets. You normally have a limited amount of time because it's not your day job, but you really want to produce something that's quality and have something that you and the group can be proud of and that the community really enjoys. So the only way that I could pull off designing for camps and cons and having stuff that I think looks pretty cool is to leverage open resources that I can get pretty quickly and don't cost the camp a lot of money, because trust me, the design budget is at the very bottom of that list. I'm lucky if we get posters or stickers. So I find it very handy. I don't think I could do my work without it. So here's the copyright crash course portion. I'll learn a little bit about what copyright is and how it works. There's the small print. We can all read that. Basically says that I am not a lawyer and I'm not responsible for this blowing up in your face. But there's some pretty cool resources here that you might want to experiment with. I don't know if I need to put that in there, but I see it in everything that's law related. So why not? So part one, what does copyright mean? It means all rights reserved to a work that you author. It's any idea in a tangible form, not just ideas, but you have to actually put it down on paper or have some manifestation of it physically. And that gives you, the author, complete domain over how people interact with that piece of property. They're not allowed to copy, distribute, modify, or consume it in any way without your permission. Now there's exceptions, fair use, we'll talk about that a little bit, which is a part of copyright. But ultimately, if you see a piece of intellectual property, you are best to assume that you need some type of permission or licensing to use that or distribute it or modify it in some way. Derivative works are when you take a piece of intellectual property that's been licensed or you somehow have permission for it and change it, remix it, modify it. If you create a plugin for Drupal that's considered a derivative work of core, you take a photograph and you make a collage out of it, that's also considered a derivative work. So this derivative work of the original work now has its own copyright as well. So now you have the original copyright stacked on top of your own, and these two things have to be compatible. You can't take a derivative of something unless you've been given permission to, and then you can't distribute that derivative unless you also have permission from the original author or their license in some way. This is an example of a derivative work. This was a pretty popular case a couple of years back when Shepard Fairey was doing a lot for the Obama campaign and distributing a lot of political propaganda during that time. The Associated Press alleged that he had derived the image and the layout from a photograph that they had taken to create this poster, which was pretty iconic, this illustration of Obama looking into the distance. So he denied it. He said that he'd never seen this photograph before, he hadn't traced it, and that even if he did, the work is so far removed from the original author's photograph that how in the world could they consider that theft or some kind of distribution of the original? Well, they took this to court, and eventually Shepard Fairey admitted that he had seen this photograph and based the illustration upon it, and they had to settle out of court. So the judge also sided with the Associated Press and said, yes, this illustration was clearly derived from this, the shape, the structure, the layout, the angle, etc., whatever their reasoning was. They said that this was too much like the other to not be considered derivative and would have to work with the Associated Press to license it if we wanted to use this image any further. Some people think that, wow, I mean, I assume that from a photograph to a painting or an illustration would be enough of a transformation. And in some cases that's true, but in this one, there were enough parallels that the judge felt that they should be considered derivatives. Fair use, I mentioned that a couple times. This is a part of copyright. This is your right to appropriate other people's intellectual property in certain circumstances. Now, there's these four tenets of fair use that the judge will consider when determining whether or not your application of someone else's property was fair or not. So it depends on the purpose of your copy in the first place. Was it to make money? Was it to falsify information? Was it for somehow financial impact or whatever? Or was it simply for learning purposes or for a demonstration or some type of other use? So it depends on the why. The nature of the copied work, so was this work published or unpublished that you copied? Was this a famous piece of work? Was this something that no one's heard of? Was it a book or was it just a blog post? It depends on the actual work that you copied itself and the circumstances in which it was already being used. And it also matters about the amount of work that you copy. So if you take a 30-second clip from a song, that's a lot different than copying the whole song and saying it's yours. Same with like a movie. If you use a little movie sample versus using the entire film reel, there's a big difference there. And ultimately, it just depends on, did your modification or interpretation of someone else's property impact the original author's ability to profit off of their intellectual property? So you take all these four elements and you weigh them on a scale and you balance them out, and that's how the courts will determine whether or not the use that you took upon this thing was actually fair or not. Now, there's nothing technically in books that says educational use, all of it across the board, is considered fair. There's nothing that says you know, making a copy and if no one else sees it is necessarily fair. The circumstances fit into these four things as being acceptable, and there's been precedent set on that. But there are a lot of circumstances where if you do something for educational purposes or whatever else, that it may not fall within these boundaries. So ultimately, you can use that as a guide, but if someone complains that their property was being used inappropriately, they can take that to court, and then the judge will have to interpret the copy based upon these four elements. This was another popular case, fair use. This was Leibowitz versus Paramount Pictures Corporation. There's a rather famous image of Demi and her baby. It was on magazine covers throughout the country and in grocery stores and everywhere. It's kind of iconic and burned into our brains. And around the same time, Naked Gun was sort of popular. It was like the thing of the 90s. And they did this spoof on the Demi Moore thing in a campaign and some of their packaging. And immediately, Leibowitz and Demi were sort of outraged, and they thought, like, you know, this was private, this was an intimate shot, this is clearly a copy of what we did. You're doing this for financial gain. And you basically copied everything. The lighting is really similar, the stance, facial expression not quite, but there's enough elements, obviously, right? Even the rings are similar. His is like a little bit bigger, a little bit gaudy, but the differences are a minutia here, right? I mean, what do you think? Were they based on each other or not? Right? Yeah, well, it came down to issue of whoever had a better lawyer. Lawyer said that Paramount Pictures, this was a parody, right? But not all cases of parody are considered fair use. But they argued down to every little intimate detail, saying from his facial expression to the ring to the application of the photo and the context somehow fell within those 4 boundaries of fair use and was not just a direct copy, even though it was for financial gain and it looked really similar, and even the format was identical. Somehow, some way, this is considered fair use. So you just never know, right? The Shepard Fairey case, it went from a photograph to an illustration, and even those look different, right? It totally new context, messaging, and everything, distribution, the whole thing was different. That was still not considered fair, but this is almost a carbon copy ripoff, and it was considered fair. So you just never know, parody or not. Like, it comes down to what you can argue. Part 4, licensing. So this is really what the whole talk is about. So you got copyright, and then the license is the adjunct onto that. It tells us a set of permissions. It's a set of instructions about what you can do with my copyrighted work. So instead of all rights reserved, it gives you, the user, some rights to do some things with that work. Every single license is different. You can create your own license. You can draft them with lawyers. Or you can use any of the pre-existing ones, such as Creative Commons, GPL, OFL, and apply those to your works as well. And each of these are very different. They have a different set of permissions that you can do. Some allow you to distribute, some allow you to copy, some allow you to make financial gains off of the derivations. It all depends, and you have to read the fine print and use the license that's most appropriate for your work. But without having a license associated with a piece of intellectual property, he said it's best to assume that it's all rights reserved until otherwise noticed. So the Creative Commons, I'm going to talk about Creative Commons mostly. That's the most relevant license for design, visual media, that kind of stuff. Commonly for software use, GPL or the MIT license. But we're going to focus mostly on Creative Commons, and it also is kind of more complicated than those, since there's 6 variations of the licenses. We're going to walk through the different steps and talk about why there's so many different ones and the spectrum of permissions that exists within there. But typically, you're free to share, copy, distribute, or perform at the very least. And then you also can't have any form of digital rights management associated with that. But then whether or not you can make money off of it and some other things, that depends on the particular license. So next we're going to talk about the 6 licenses and some of the differences between them. So the first one, all the licenses require you to give attribution to the original author. If I borrow a photograph from someone and it's just the first Creative Commons license, I can do anything from create a derivation, I can sell it, I can distribute it, copy it, basically do anything I want with that work as long as I give credit to the original author. The second license, again, having to give credit to that author, but I can't use any of my applications, distributions for financial gain. So I could put it on my blog, I can make copies of it, could publish it even, but as long as I'm not drawing any money off of that copy, it's all good. The third license is attribution with share alike, which means that the original work was authored and licensed with a Creative Commons license. Every time I make a copy or a derivation of that work, it must also contain the very same license. So that's meant by sharing alike. It's kind of like GPL, how every single copy of something from that license also has to be replicated with the same license. The fourth one, attribution, no commercial, and share alike. So now we're going to just kind of see different combinations of this modular system of licensing and different ways that they come together. So no financial gains, and you must also share alike any further derivations or copies of that work. The next one, attribution plus no derivatives. So this says that I'll put a photograph out into the internet, you can copy it, you can share it, but please don't modify it or change it in any way. So no photoshopping, no cropping, no editing, none of that, but you're still free to make commercial gains off of that thing, distribute it, publish it, as you see fit, as long as you're not changing that work at all. And the last one is what some people call the free advertising license, and this is the most restrictive of all the Creative Commons licenses. So you can't change the original work in any way. You can't make any financial gains off of that whatsoever either. So I think like a popular example would be the Getty Images Archive just opened up all their works, I think, using this license. So you can use most of their photography in the library now in a blog post or something, but you can't use it for financial gains. You can't make derivatives of it. But it's cool that you can still leverage those things and put them in your blog and share them without having to worry about them sending lawyers after you. But it's also the most restrictive, so there's not too much you can do with that. So there's this idea of modularity in licensing. So one piece of copyrighted work is actually a grouping of multiple copyrighted works normally. Take, for example, a magazine or a book layout. You've got photography, you've got copy, you've got the actual layout of the book, maybe either cover. It's a whole set of various different pieces. Each of those have their own license associated with them, the photographer, the copywriter, the author, the designer. You have all of these elements coming together to create one new work. And you have to make sure that if you're creating something that is Open's licensed, you want to say a book's Creative Commons, everything within that book has to be compatible with the license that you're using at the very end. Website is a good example of this type of modular licensing system. And I'll walk you through examples of how we can break this out into different types of licenses and the types I used. So this is a project I did a couple of months ago now for a political action committee, May Day. It's actually initiated by Lawrence Lessig. And this is, they were raising money to help reduce the influence of money in politics, particularly Congress. And this was a Kickstarter-like campaign that we ran. So I helped out and designed the homepage. And we wanted the whole project to be Creative Commons. You know, Larry is one of the founders of it. And, you know, the whole group believes very strongly in that foundation, and as do I. So, you know, I was more than glad to comply with that, which means that everything, all the resources and tools that I used for this also had to be licensed compatibly. So, you know, it's hard to see on the screen, but in the background there's a cool pattern from subtlepatterns.com, which is an awesome library of open source Creative Commons little snippets and patterns. So that's one little piece, that background pattern, right? We didn't have to pay for it, and it's open license. The fonts that we used was an open font stack from Google Fonts, the OFL license, completely open, and again, compatible with the Creative Commons license. Here, even these little icons, those stars, you know, that came from somewhere. Those are copyrighted material. That came from a font pack called Font Awesome. We'll talk about that a little bit. It's pretty cool. And even this video here is a separate piece of intellectual property that carried its own license. And again, has to be Creative Commons compatible. I think the video itself was Creative Commons. And then, it's hard to see it better. The background image behind the video was also something that I pulled from Flickr, which again had to have some type of open context behind it. And then there's the code, right? So that also has a separate license on top of it. I think everything was custom, and I'm not sure whether or not we used GPL or Creative Commons for the code as well. The main idea here is that you have all of these different elements coming together to create one end product, and you have to make sure that all of the distribution and licensing and permissions are compatible with each other. Otherwise, you'll have holes in your end work. All right, so point 6, work for hire. So if you work at a place and you're considered an employee, and the criteria of that can differ depending on where you are within the country or even within the world. But if on paper, for some reason, you're considered an employee, it doesn't even have to be full-time. The boss, all of these things automatically go straight to the person or your agency or to whomever that you're working for. So whereas if you're a contractor and you're not considered an employee and it's not in your contract, right, by default, you still own the copyright to the works that you're creating. So a lot of people think that if you're working in an agency and you're creating works, that that still belongs to you somehow, and technically your company doesn't have to really permit you any rights to those, to not even use them in your portfolio. So be careful, if you're a designer especially, or a developer and you need code samples or things to put in your portfolio, make sure that the person that you're working with will at least let you use those works to show other people as examples of the work that you've done. They don't necessarily have to let you do that, and one could argue that it's fair use, but technically, since the copyright is theirs, it's ultimately their decision. And all you contractors out there, work as hard as you can to keep your copyright. That's not necessarily indebted to anyone else but yourself. Personally, if a client wants to end the copyright, own it at the end of a project, I charge extra for that, because typically the default would be that I get to keep it. I'm simply licensing them a non-exclusive deal to use that as a piece of work. So I sort of consider it a luxury for people to own my copyright and let them pay for it. And this will sum up the little end of the crash course before we get into talking about some of the resources and tools. But I think it's kind of fun to walk through some of the things I've heard over the years and pick out some of the major misconceptions that some people have about copyright. I often hear people saying, well, I gave the author credit. I'm like, that's great, but it doesn't really mean anything. Technically, you're still using an unauthorized copy of some author's copyrighted material. So, although this might help better your case if it were to go to court, technically there's nothing in the books that's saying giving anyone credit for anything gives you permission to use that property. And I also hear a lot of times that all educational use is fair use. That's also not true. The reason why a lot of educational use is fair use is because normally you're using things out of the original context and using them as an example or as a way of explaining a certain point or something, whereas you're not just taking a full copy of a textbook and using that in your classroom. So if you were to do that, for example, that's obviously an egregious verbatim copy of something. You can't just take a full book and distribute that. But if I was to take a snippet out of a song as an example to talk about democracy in Thailand or whatever, if you're taking something out of context and using it to explain a point, so that's normally why people think that educational things are okay to use. Big confusion that I see a lot is that people think that if something is free, like a free icon pack or download something for free, they think that it's automatically open source. And that's not necessarily true at all. And a lot of people think that if something is open, it has to be free. And that's not true either. You can charge money for things that are open source. WordPress does it every single day. Those premium plugins that you're paying for, those have the same GPL license that every other part of WordPress does. So technically, if you can find those premium plugins, you're free to do anything that you want with them. I think it's kind of an interesting business model that they're running, and I think it should be more transparent that these things are GPL licensed. But I guess the man's got to eat, but I still think it should be the consumer's option at the end of the day. It's just my own rant. And a lot of people think that copyright must be registered, and that's not true. You don't have to register anything. It's pretty easy. The second that you fix something in a tangible form, it's the magical copyright guides from above make it so. You don't have to write the copyright symbol on it. You don't have to go to the office. The only benefit of registering is that if someone actually does make a copy of your work and you take it to court, it's easier to prove that that was your work, of course, but you can also get more money at the end of the day. So not only are you suing them for the actual damages and money that was made off of the unauthorized copy, but you can also sue them for what's called statutory purposes, which means you can get money that they would have potentially taken from you by appropriating your work. So, depends on whether or not you think something's going to be insanely popular. and just how good of a lawyer you have really too. Normally, I would say you don't even have to worry about registering your copyright because zoning card's going to be expensive, and it's unlikely that you're going to want to do that anyway. All right, so here's the fun part. We'll talk about different resources, websites, tools that you can use, most of which are completely open and out there on the web. Actually, they all are. So they're free in some way. This is a really good resource created by the Creative Commons agency. It's sort of like Google search, and it does a lot of the same things that Google does. But this is the window to Creative Commons licensed works throughout the web. And I use this a lot to quickly find images or icons, fonts, and that kind of stuff. It's really convenient. You can pick from all these different services, find music, images, whatever else, and then you decide on whether or not you want to use it for commercial purposes, or if you need to make modifications of that work, and they kind of take care of all the rest for you. It's a really nice vector in discovering the wide world of open license works, because it can be kind of hard to find these things if you're not too versed in where they're coming from. So this makes it easy. It's a fun place to start poking around, and it can be found right on the Creative Commons website. So the U.S. government is one of my favorite sources of copyright-free media, and so all works created by U.S. federal employees are not subject to copyright, which means they're completely in the public domain. Now, this, of course, doesn't apply to contractors working for the government. It's like we said, contractors' work is not work for hire, unless otherwise stated, so the work performed by a government contractor would belong to them and therefore not in the public domain. But the majority of works, photographs, multimedia that comes from the U.S. government is normally created by employees within the agency.
When you say public domain, is that the same thing as Creative Commons? Or are they different?
It is not. However, there is a Creative Commons license that puts things in the public domain. How's that for confusing, right? Yeah. So public domain means that something does not have any copyright associated with it at all. So normally a copyrighted work lasts for, I think, 70 years past the death of an author. So after that 70 years is expired, then that work goes into the public domain. And copyright no longer exists, and anyone can use that work to do whatever they want. Copy, modify, distribute, put your name on it, sell it, put in a frame, whatever you want. It's a free game. Same thing goes for government employee stuff. Never copyright that in the beginning. So NASA has some awesome images. This website is a total disaster to work through. It's really hard to find any content. I suggest using their Flickr or their Instagram instead. But this was just to illustrate the point that government works are uncopyrighted, and it's totally fair game. Another amazing example of copyright-free works is from the Bureau of Land Management in the U.S. too. Their Instagram is definitely better than their website, easy to navigate. Never again do you have to worry about getting cheesy landscape photos from stock photography websites. You can get some really high-end, stunning, gorgeous stuff from here, and this is just a fantastic resource. You can even create your own Etsy store and frame these things and say that they were yours. It doesn't matter because there's no copyright associated with them. But this stream is a lot of fun. It's super gorgeous, and it's really cool that this is our tax dollars at work for something that is pretty awesome for once. So check them out. BLM, a lot of good stuff. Bunch of different Flickr feeds too. I just used Instagram as an example of another means of distribution that they're using. Flickr Commons, there's a whole area on Flickr reserved for things that are in the public domain or open licensed in some way. This I got through their search engine. Just a quick example of the word modern. I'm not quite sure how modern some of these things are or even why they were in that query, but just to give you an example of, there's a huge diverse range of media to be drawn from, and a lot of it is housed within the Flickr Commons as well. So that's a fun, safe place that you can go poking around if you're looking for open licensed works of some sort. Wikimedia is also pretty good. Starting to look a little stock photography-ish, but still gorgeous quality, high-end stuff that you'd normally have to pay a lot of money for. So that's also a fun place to look around if you need background images or stuff for a slideshow, placeholder content, or whatever else. They have a huge library of pretty decent work there too. One of my favorite websites on the internet. It's growing more and more every day. It's been around for a while. It's gorgeous, well organized, and everything here is Creative Commons licensed in some way. Even some of it is in the public domain as well. Now they've found a way to monetize this, and a lot of designers who have an account here use this as a source of income. The benefit of paying for some of these things on the website is that you don't have to give attribution to the original author or deal with putting a credits page on your website or any of the other licensing nuances that may be associated with it. So if you want to just buy these things for your clients so that they don't have to worry about following the guidelines of the original author's license, you just pay $2 for an icon or something. It's a really fair deal, and you can just forget about the whole licensing thing to begin with, and then the rights are transferred over to the client. But either to use the site. And I think that's really cool. I like how that they give you the user the choice or the opportunity to pay if you want to or if you can. But if you want to, carry on the creative licensing mantra and you could still afford it, you can do that as well. So there's a lot of stuff. It's pretty handy, just the library keeps growing every day. So it's easy to use too. I think it's cool that they found a way to monetize something that's open and still give people the option. Font Awesome. This is a super cool project. It's a lot of fun. Developers love it. Designers love it. It's super quick. It's lightweight, and it's totally open font license, which is one of the most liberal. It's totally free. You can do whatever you want with it. You can modify it. You can change it, fork it, do whatever you need to. It's a really cool resource. Ton of icons. It's all based with. It's pretty easy to install too. You just kind of put a little link in your header and put the I tag associated with the CSS class, and you're off and running. So it's quick, it's lightweight, scalable, and totally open source too. I use this a lot. Font Squirrel. This is an open license font repository, and it contains a whole spectrum of various open source licenses, anything from Creative Commons to public domain and open font license. So here you got to be a little bit careful with just how open and how free something is. Some of these fonts are completely open licensed, or totally in the public domain. You don't have to worry about how many users are using your website, what type of distribution you're using, the context, or whatever else. But some of these open fonts have really restrictive licenses associated with them, saying that if you have more than X amount of users visiting your site, then you have to start paying a certain fee, or you can only use it in so many different contexts or in specific ways. So you got to be careful. You can't just assume that everything here is totally open. And it even says 100% free for commercial use, but that has stipulations associated with it. It might be as long as there's only 10 people visiting your website. I've even gotten in trouble by using some of these in certain contexts. So I've learned that always read the fine print. It's an amazing resource and a huge library of some interesting stuff, but you got to read the fine print here for sure. All right, Google Fonts. This is my typical go-to because you don't have to read any of the fine print. All of it is just under one single license, the open font license, and like I said, that's one of the more open ones. So there's no stipulations with the amount of users, the types of distribution, the number of devices, and all that stuff. It's just a lot of real high-quality stuff. And there's fonts here from Adobe, there's fonts here from Google. Even Google's really stepped up their design game. They have a nice series of fonts available here as well. And originally this was not the most awesome place to find fonts, and people kind of had a sour attitude towards open licensing with fonts, and thought that you wouldn't get as high of a quality product out of them as in some of the pay-for-play stuff. But that's just not true anymore. Companies are investing a lot of money to pay designers full-time to actually make beautiful fonts that are completely open. So I use this in a lot of projects. I find a lot of those pay-for-font services like Typekit and whatever else really painful and a huge hassle to put up with, and I almost just don't want to put my clients through that, having to create an account and license them for a particular amount of time and all that stuff. There's so many hoops to jump through with web licensing right now that I've almost given up on paying for fonts altogether, and that's pretty much been okay with this Google Fonts resource. So huge fan of it. Check it out. And this is the final example here. It's a community for designers like Behance, kind of like Dribble. It's not a totally open scenario, but when you register for an account and you're posting your works, they give you the opportunity to license what you're showcasing under a certain type of Creative Commons license. And it's pretty cool because it's a huge community. It's really popular. It's hip, it's trendy, a lot of really high quality work. And what's happened is that over 75% of the works that you can find on this website showcased are Creative Commons licensed. So they're creating this huge repository of open stuff that you can use for inspiration, put in your blogs, and distribute. Be careful with exactly how you're using those works, but it's 75% of works that people probably would have never even considered using Creative Commons for. So you find a lot of interesting stuff here and a lot of cool food for thought. And I think it's cool that they're help grow this community of people who want to share and inspire each other. So that's it. Thank you so much. Like I said, my name's Darius. Find me on Twitter or email me if you have any questions. Guys in the audience have any questions about anything? This threw a lot at you. Yeah.
So like when people are blogging and things like that,
yeah.
so they want to blog on specific, say, company,
Mm-hmm.
can they just pick up images from their site and use it in the blog, or do they have to?
No, not really. I mean, again, that can fall into fair use, right? If they're using those images to do a review of a product, probably. But if they're using those in some kind of slideshow of cars or something, or making a book about like hot cars of the 90s or something, that context would likely not be okay, right? So it depends on the context that you're using those images from. Normally, you can't just go ripping stuff from a website and put it in your blog, unless it's for a commentary, and it's just a little bit too. And are you making money off of this blog, or is it just a hobbyist's blog? So maybe the best answer. Anything? Oh, yeah.
If you're looking at a client's site,
Yep.
we don't have to worry about licensing.
Well, it depends on who's going to own the copyright at the end of that. So if you're doing work for a company, they typically want the copyright at the end. So if you're working for an agency, part of that contract is going to be that owns the copyright to that work. So all the images that you're using have to be licensed by GE at the end of the day. So if they're not, you're not going to get in trouble because it's not your copyrighted work. But yes, all of those elements have to be licensed by the person who will be owning it at the end of the day.
How does this, I mean, how do you copyright the work outside of just like attaching some document to it?
It happens automatically. I swear to God. Like it's kind of ridiculous. You could. Well, there is. You can register it, right? And that's if you want to sort of build a case for yourself and get statutory losses in the court of law and all that stuff. But technically, you don't need it to sue someone for copyright infringement. The second you put a smiley face on a Post-it note, it is automatically copyrighted. You don't have to put any indication of it. It wasn't always that way. But now copyright just falls out of the sky once you have an idea fixed in some tangible form. Isn't it? Yeah.
So I'm new to this whole thing, but if I was to build a website for someone and I took a font that is copyrighted and I had no idea and I put it on their website, am I going to get sued?
Maybe. Well, you'll get a cease and desist order first.
So I should use Creative Commons or purchase the font to build a website.
Totally.
I can't just use Arial or like a common.
Well, yeah, that's where it gets interesting. So if you have a license for Arial because that came as part of your operating system, typically, right? And so that's probably fine, right? Because you as a designer, you bought Windows or Mac or whatever, and so in that license, those licenses are pretty open. Like if you bought our software, do whatever you want with it. So that's fine.
Would there be a distinction between using the Arial font and an image on the website using Arial font versus embedding
that right?
the website?
There is a difference there too, right? Yeah. So you couldn't necessarily. It gets tricky because that's a different form of distribution, right? So it depends. Sometimes it doesn't matter though. Like originally when Arial was put out in first license, it said it's a fair game. As long as you have this license, you don't have to have a separate web license on top of that. But now a lot of contemporary fonts have it written in that this is a print license only. If you want to use this for web applications, you're going to have to use our web font. So if the Arial license, which I seriously doubt, has a separate contingency for web versus print, yes, but other fonts, absolutely. Like Gotham, right? Super huge, popular, expensive, awesome font. That's everywhere. that's very specific licensing for every context that that is used in, and the number of authors and how many people are using the system and where you're using it and how, all that stuff. It just gets so insanely complicated. I don't even use fonts that are new on the web anymore unless the client has a lot of money and they want to deal with it. It's kind of sad, but they've made it so convoluted that I think they're putting their own foot in their mouth.
So you suggest just sticking with Creative Commons?
I do, but be careful. Like I said, if you don't, if you're not too comfortable with the licensing side of stuff, you're a little sketchy on the small print and all that stuff. Go to the Google fonts. One license, totally open. Doesn't matter what you do with that stuff. It's fair game.
And then if it is like a share alike or give attribution, do you put that somewhere in your website, like the bottom?
Yeah, right. So what is considered a decent form of attribution for Creative Commons? You need at least the author's name, the year that it was copyrighted, and a link to the source is good too. That's not required, but the bare minimum is the original date of authorship and the name of that author. Yeah. And you can put that in a credits page, or you can put it right underneath the image, as long as it exists on the website in some form.
Have you used a site called thefont.com?
Yes, I have.
They have, like in the search thing, or custom try the font thing, they have an option where they say you've got like public domain, GPL, or OFL. That's one option.
Yep.
And there's one that says 100% free. And then there's one that says donation.
Okay, so those two, I'm not familiar with. Those are custom licenses. So 100% free, they might be implying that it is in the public domain.
The other option did actually say public domain /GPL/OFL. The three you mentioned.
So the one option says all three of those things?
Yes. Well, they might just.
Oh, weird. Okay, you know, I would. 100% free means nothing. Yeah, I'm curious. I will look into that.
Okay.
Because that doesn't mean that there's a license of any sort on there. They're implying it, sort of, but there is no 100% free license that's commonly used anywhere.
The only one that seems really soft and safe and software development.
Or GPL, BSD, GPL, MIT.
Even GPL, like,
You have to share alike, right? Yeah. Well, I mean, even the MIT one, you have to put the. So every time you make a copy or distribution of something that has the MIT license, it must carry the MIT license with it. Unless you create, if you have a derivative work, you don't have to use the MIT license on that derivation. So the only difference really between the MIT and the GPL is this derivation licensing thing. So I say they're pretty similar in how you use them.
I didn't know in like GPL you could distribute it. I thought you had to like somehow distribute the GPL code separately,
Separately from.
like your application, like if you're going to sell an app, but like as soon as it starts.
Oh no, you can sell GPL all day. It permits you to do that. It's culture license, so people should be able to do whatever they want with it as long as you share it in the same way.
Or at least you have to include all the source code.
You have to just include the same license, the share alike. Because if you make a derivation of something, it's a brand new work, and it's considered its own copyrighted entity. But you have to use the GPL license on that new entity. You don't have to put like the original source code in your code, because it's a new piece. So the only difference really is whether or not you have to use the same license or not. It's so complicated. It's insane. There's so many versions upon versions of these licenses.
I was gonna say, like, okay, it's like, $2,000 to a website, and I'm going to need $4,000 for
Yep.
make sure that
Pretty much. It's a nightmare.
So if you were
this is
for
pretty
yourself,
popular, right?
Oh, yeah, thank you.
you have to have a lawyer? Like,
I'm sorry?
is it like suggested to hire a lawyer if you work for yourself?
I would suggest you getting a really rock-solid contract drafted up with a lawyer that protects you from a lot of these scenarios. Like, if somehow something that I do gets you into trouble for intellectual copyright infringement or whatever, you're passing over the copyright to your client, I am not responsible. So yeah, you need to spend a little bit of money up front with a lawyer, but as long as you create this overarching layer of protection for yourself, that's the responsible thing to do. I haven't done that, but, but when I worked at an agency, I did get in trouble once for using a font from Font Squirrel. So it said 20,000 users, and it was a big company. They had 50,000 users or whatever. I was like, oh shit. We fortunately they eventually paid the license for it, and we settled out. But I felt kind of stupid. It could have been my ass, but it was the agency. So I had that going for me.
How did whoever, how did the person find out that there were actually 50,000 people?
You know what? It wasn't the font proprietor. It was their internal legal team that was reviewing all of the assets.
They came back to you before it actually. So how
It was launched and live, and no, it was out there.
How did the proprietor find out?
Yeah, like how did they detect that?
There's no like automatic system that you can't just like go searching for people who are using your font. But it was the internal teams in the company that I made the website for that discovered that this license was not valid.
So it wasn't like external.
No, there wasn't any pressure from outside.
Although it's becoming a profit center or it is a profit center for a lot of organizations.
Some huge, yeah.
A whole team of IP lawyers.
They do. Apple, big time. Yeah, they have an entire team that scours the entire web looking for copyright violations.
It's like money already.
Oh, big time. Oh yeah. No, you got to be careful. Like, and consider where you're taking your stuff from and who you're borrowing from. It's complicated.
Just looking at the MIT license, and they say that copyright notice and permission notice shall be included in all copies or submitted for software.
But not derivations. So if you create,
It does not say that.
right, because it doesn't say that. If it doesn't say that, that means you can do it. Right, no, you don't lose your copyright. So the thing with the MIT license is you write a piece of software, I copy it in entirety, throw it into my new work. I don't change it at all. I'm just taking this chunk of source code. It has to have the MIT license on it. But if I change it to the fact where it becomes a derivative work, that derivation does not have to have the license on it.
Well, it depends on your definition. We can make a small change to that.
I mean, really?
You change the variable, that's a root that work. It's still substantially verifiable.
Honestly, I don't think that there is that much of a difference between substantial or not. Like, once you change something in some way, you've modified that intellectual property. It becomes your copyright. The copyright from that one also exists.
It's true that you can't copy them.
Yep.
They still have their copy.
Oh, sure. They do. Yeah, but your new work has a new copyright, and it doesn't have to have. Whereas the GPL, your new work would have to have GPL on it as well. I'll shut down.
Was that the crux of your talk?
That was. Yeah, the QA on this one usually goes for a while. GPL, MIT, BSD, those are the big boys. Yeah. Yeah, right. Open as in free beer.
I hope. Hey, I got one for you.
Oh,
I just bought one.
good. I have HDMI.
Oh, I know. I almost made that mistake too.
I actually just